On go.
Okay, hi everybody. I'm Bob Carr. I'm the founder of Link SV and with Don DeBruin, my partner. And for the last year, we've put on a monthly seminar with Roger Royce, all about things to be aware of when you're starting a company. We divided to 12 topics and covered a lot of areas this last year, enough to make me very concerned for the next company I'm going to co-found. And I think today we're going to do a case study, Roger. It probably ties a lot of interesting things together, and it should be a great session. So Roger and I have been friends for 30 years, and he's like the dean in Silicon Valley for startups, and he's written a couple of books and on the subject, and it's all great. So Roger, let's have at it. Perfect.
Okay, thanks, Bob. And thank you everybody for being here. This is the last, like Bob says, last of a series. We've done this for 12 months now. This is our 12th one, and this is the end. And this week we're just going to, or this month, I should say, and this particular presentation, we're just going to pull everything together and do it in the case study format. So I guess I'm all the characters in this case study, but just we're going to go from start to finish, and I'm going to just posit a few different hypotheticals. So you should be seeing my presentation mode startup screen. And as always, this is just information. This is not legal advice. And, I'm an attorney. I'm not your attorney. Your facts may differ. You change the facts, you change the result. So just take this as information. And plus, the other thing I should mention, because I've got hundreds of videos up now, and one of the things I should remind people of is that the law does change. And what might have been accurate a year ago might not be accurate today. And we're seeing that actually things are changing really quickly right now in a lot of different areas that affect startups. So, with all those disclaimers and qualifications, why don't we go ahead? Here is the fact scenario. The founder A, we'll call him because I'm unimaginative, comes to see lawyer, we'll call that'll be me, about forming a company. And he says, look, I've got two co-founders. I live here in California. My co-founders, they couldn't come visit you here today with me because they're in other states, but we're all three going to start this company. We're all going to be directors. We're all going to be officers. We're all going to be shareholders. We got this really cool AI-enabled tool that helps build sites. And everybody that we've talked to says it's just a great idea. In fact, we asked ChatGPT and they said it was a great idea. By the way, try this sometime. I asked ChatGPT if it thought I had this idea for making sunglasses for indoor cats. Do you think that's a good idea? And ChatGPT thought that was an awesome idea. In fact, it wanted to build me a business plan. So, as an aside, I'm not making that up. Okay, so founder A is a business guy. He's got a job at a bank. Other co-founders are technical, and they work for local software companies or software companies wherever they live. And one of the techies, he's willing to quit her job and go full time on a startup. These others, they can only do it part time, nights, weekends, that kind of thing. And then all just as an aside, founder A is single, one co-founder is married, one's divorced. That'll become relevant in a minute. So now you should see a slide that says legal issues, formation legal issues. So, what are the legal issues that we have to pause on in this fact scenario right from the start? So, I guess the first one here is, well, who is the client in this scenario, right? We've got these, there are three people forming a company. I'm only talking to one of them. Is founder A the client? Are all three of them the client? Or is the company to be formed the client? And I know it's not something you probably think much about as a startup founder, but trust me, as lawyers, this is the very first question we think about because it has pretty profound implications. Because as lawyers, we have a duty to our client, and that means to the exclusion of non-clients. So one of the first things I want to do is just clarify who am I representing here. Now, my super strong preference is always to represent the company. And that's a little bit of an issue because we don't have a company yet. It hasn't been formed. And what a lot of lawyers will do is they'll represent whoever found them first, founder A in this case, until the company gets formed. And then they will terminate that representation and then start a new representation with the company. I find here in Silicon Valley that most of the time, we don't bother with that much formality. We'll just represent the company to be formed. But one of the things we rarely do is represent any one individual throughout this process. Startups, if you were a bigger company, then yes. But startups, they tend to want to have one lawyer represent the company and the founders go unrepresented. And I'm not saying that's right or wrong. I'm saying it's the kind of thing that the founder ought to be aware of because you, the founders, are going to enter into contracts with that company. And it is, even though it's not confrontational, it is adversarial in the sense that it's zero sum. What's good for you might not be as good for the company. So keep that in mind, who the lawyer is actually representing. And not to put too fine a point on it, but you might remember that movie, Social Network or something like that, the one about the Facebook founding, where one of the founders, is sitting in the deposition, and the lawyer said, "Well, gee, if you didn't understand this vesting restriction, why didn't you have your lawyer explain it to you?" And he said, "I thought I did have my lawyer explain it to me." He said, "I didn't realize the company's lawyer wasn't my lawyer." So just keep that in mind. Okay, now let's get into the substance of it. What kind of company should they form? And we could do hours on this. In fact, I think we did do an hour on this early on. And the real answer here, just to kind of cut to the chase, is these days, if it is a typical tech startup, it's going to start as a Delaware C corporation. Now, you can make a case for a limited liability company taxed as a partnership, but eventually that's going to have to incorporate if you're going to get venture capital money, because it's not a legal thing as much as it is a practical market thing. They just will not invest in anything other than a C corporation, usually Delaware. And as we talked about earlier, we're finding that that's changing a little bit, the Delaware aspect of that, because Delaware has had some recent case law that makes it a little less attractive than it used to be. And other states have revised their statutes to be more attractive. Texas comes to mind. I'm licensed in Nevada, so of course I like Nevada. But for the most part, currently it's going to be a C Corp. It's not going to be an S Corp because VCs can't invest in that. And it's probably, if it starts as an LLC, it's going to convert down the road. So 99% of the time, we just start with a C corporation. And 99% of the time, I'll start with Delaware because I know that works, even though we can quibble about the details and, dance on the head of a pin as to, whether Delaware or Texas or Nevada is best. Now, even though it is formed under Delaware law, none of these three founders live in Delaware. So, but they do live somewhere. And wherever they live, because they're going to be officers, that corporation is going to have a legal presence in that state where they live. They're going to technically have an office there. And because they have an office there, they have to do what we call as qualify. And that basically means you tell the Secretary of State that you have a presence in the state and you're subject to the jurisdiction of the state. And we basically just file a qualification. It's a simple thing, but if you're in California in particular, it's a simple thing to do, but there are penalties if you don't. So it's the kind of thing that we definitely want to do. One of the effects of that, by the way, is that's even though technically doing interstate business is not the same as doing business in a state for tax and for corporate law purposes, but yeah, try to explain that to the FTB. You will talk to your blue in the face, and they'll tell you it's the same thing. So when a company qualifies here, I tell them just plan on filing a tax return here as well. Even though we can make good arguments why you shouldn't have to. It's just easier to do it. Now let's get into the bigger issues. We've got three founders. One of them's full-time, two are part-time, one's business, two are technical. So they're bringing different skill sets to the business. how do they split up equity? And I know I've done hours and hours on this, and we have covered it previously on the formation section. And there are numerous methods, right? There's just the good old equal split method, right? And then we figure it out later, which is not as bad as it sounds because you're going to have so many opportunities to revisit that determination down the road. You're going to have vesting and revesting. You might have some top-up stock grants, or you might have a VC come along and kind of make a pancake out of the whole thing and reset your cap table. So I don't stress that much about the original decision, but it does have some significance uh, because people have to agree to any changes down the road. So one is equal split. Another one, there's a method that I used to be a big advocate for, and I'll still, I'm still aware of it, and I understand it, and I'll use it, and I have no criticisms, that we call dynamic split, where we basically put a formula in place that measures the relative inputs of the parties as they go along. Then when we get to the first angel financing, we stop and take a picture, add up all those weighted inputs, and poof, that's our percentages. I like that because it has a little bit of a feeling of objectivity to it. There is a other formula, right? Here's a simple formula. You're full-time and I'm part-time, so you should get twice as much. All right, something like that. At least it has some sort of, I guess, a little bit of an objective feel to it. But really, ultimately, what I tend to come down to most often is a very, very subjective equity split. And that's where we just sit down. And if you guys, the founders, haven't figured it out by the time you come see me, we'll just sit down and just talk it through and get a sense as to what we can all agree on. And that brings us to just agreed split. Which is a little dangerous because sometimes that just means the person who can pound their fist on the table the loudest gets the most equity. But this is one of those really fuzzy things. It's not really law, it's more startup. From my standpoint, I just need to know what the parties have agreed to so we can paper it and issue the shares because we want to get the shares issued very early, like almost immediately on formation or incorporation for lots of good reasons, mostly because everybody's very agreeable at that point. And at that point, we can also very easily get people to sign other founder agreements, in particular, vesting agreements. And this is something that there's just really no argument about this anymore. Uh, Founders should have vesting in place when they form a company. It's going to be imposed on a company later anyway, whether they do it or not. It's just easier to get everybody to agree up front. I mentioned buy sells. Maybe I'll come back to that. I'll just tell you we don't see that very often in startup land. And the reason why is because a buy sell presupposes that there is some value there that's going to be bought or sold if a founder leaves. And in startup land, there really is very little value until the company gets financed. I mean, if it doesn't get some money in the door, none of the stuff usually matters. And at that point, then you've got a financier weighing in with all sorts of restrictions that you might expect to see in a buy-sell agreement. So we just don't see that. My closely held companies all the time, but rarely in startups. Pre-incorporation agreements, everybody wants to talk about them. I rarely do it. And the reason why is if you're going to, well, two reasons. Number one, if a company is going to go to the trouble of putting in place an agreement that says what stock we are going to issue and what roles people are going to have, just put the stock purchase agreements in place and save yourself the extra fees. And secondly, you're not really gaining much through a pre-incorporation agreement because I do believe that is an offer of securities in itself. So you got to go through the same rigmarole as if you were to just issue the stock. Now, here's the big sleeper issue. And actually, I put this as number 8, but it really should be up there closer to 1 because it is almost the first question that I have to ask when I get 1 or 3 founders to sit down in front of me. And that is, do you have a job? What do you do? Did you sign a confidential information agreement and invention assignment? The answer is always yes. And is this startup going to conflict with your existing relationship? Because if that happens, you're sort of dead on arrival, right? Because now you're just building something that might belong to somebody else. So the rule is for employees in California is that as long as you're building it on your own time with your own facilities, meaning not using the company computer or during company office hours, and if it does not relate too closely to what you've been hired to do for your existing employer, you're okay. And that is an exception to any invention assignment you might have signed that the law imposes. You'll always find that in the confidential, that exception, that carve out, that Labor Code 2870 carve out in the confidential information agreement, but you don't need it because the law just imposes that in there, whether it's in there or not. So we really have to examine this and say, look, you've been hired by this big software company to develop this exact software, and you've decided to go across the street, even on nights and weekends and at home, and build it on your own. Well, you're breaching your duties to your existing employer. And like I say, you're just going to get a cease and desist letter as soon as you get started. So we really have to resolve that before we do anything else. Okay, we talked about, you know what, we've already talked about founder equity. The other thing I want to mention about this is that, so now the founders will tell me, okay, we're okay on the equity and we got lots of equity. So, that's great, but we don't have a lot of cash. But you know what? After we get financed, look at all this time we're putting in. And, I've had people do this, that, they'll go out and, um, do their market research and find out that, gee, public company CEOs make this much. So I should make pretty close to that much because I'm as awesome as they are. And since you don't have cash to pay me, how about we just put this little notation right in the financials and maybe even in a board resolution that as soon as we get financed, I'll get paid all this back pay. So there's a couple problems with that. Let me get to those. The first problem with that, and this is not in the order that's presented on the screens, is that your investors may not let you get away with that. In fact, the answer is usually no. Your investors are going to say, look, I don't want my money going into a company and then going right back out to the founders. You got stock for your services, not a bunch of cash. So I'm not going to let you do that. And you really should tell them about it, or we'll get to that later. You may have other problems of non-disclosure. The second problem is a tax problem, and that's 409A. Now, there are ways you can have deferred compensation in a company, but you have to follow the formalities of Section 409A. And it's pretty rare that an early stage startup is going to do that, is going to go to that much trouble. So usually the answer is no, we're not going to have deferred comp. When we get there, maybe we can do something for you when you do get financed. But to have an agreement now that says, for the work I'm doing this year, I get paid next year, that's deferred comp, right? And that means we got to comply with 409A, even if the investors will let us get away with it. And if we don't, there are taxes, there are penalties, there are an interest. It adds up to, and there's withholding obligations by the company, and it adds up to an obligation that just cannot be justified, right? The cost of doing that just can't be justified. So even though people want to do that, we have to be extremely careful about that. And there are ways you can do it, but it's going to require a conversation. Now, the other thing I want to mention is that we have federal and state minimum wage laws. And under both federal and by state, I mean California, I'm speaking specifically of California. Other states, of course, have minimum wage laws. But under those minimum wage laws, all employees, whether you're a founder or not, have to be paid currently, have to be paid in cash. Now, there is an exception for federal minimum wage laws called the partner exception. And that's what most founders rely on when they don't get paid. But keep in mind, it's a federal exception, not a state exception. So it's not perfect. And what we really rely on is the fact that you don't expect founders to sue their own companies for minimum wage. But nevertheless, this is one of those, that's Hollywood kind of scenarios where people will do things that really are on the edge of what the law will allow. Now, we don't have that exception for non-founders, so we're going to get into that a little bit more. The type of equity held, it's always common stock. Every once in a while, somebody will say, well, gee, I want preferred stock because I've heard that's better. Not for service providers, for a lot of reasons. Really, you save the preferred stock for the investors. Why is that? Because you sell preferred at a much higher value than the common, and you get way more bang for your buck, more for your dollar by selling preferred. Plus, your investors may make you recap it anyway if you try to put preferred in earlier. Now, not always. I mean, I've seen founders do this where they really are putting cash in, but it's pretty rare, especially given transactional costs of putting preferred stock in place too early. Vesting. Now, we talked about how we're going to split up the equity. But what happens if let's say we just decide we got 3 founders, we're going to split it 3 ways. And 6 months from now, one of the founders says, you know what, the heck with this startup stuff. I quit. I'm just going to take my 1/3 of the company and move to Hawaii. And we talked earlier in this series about companies where that has quite famously happened. It's all over the press. Well, that's why you need a vesting restriction. And it's for 2 things. Number one, you can't be carrying that much dead weight on your cap table. There won't be enough stock left over to motivate the founders after you bring the investors in. So you can't have inactive common stockholders who hold that much equity on a cap table. It's just too much. It's too much for the company to bear. Secondly, you need that stock back so you can go replace the founder that left, that quit. So we see vesting always in startups, even among founders. And the standard now, I mean, I used to say it's somewhere from 3 to 5 years. I'd say the standard is 4 years with a 1-year cliff. There are other transfer restrictions that should always be put in place at formation. One is a right of first refusal. And by the way, if you don't have that, it's awfully tough to know who owns it. It's hard to track who owns the shares of your company. And I have seen more than once companies that didn't bother with any transfer restrictions, and they got to exit, and the buyer said, look, we can't do a stock deal because we don't know who owns your company because you've got no way of knowing. So whether that's right or not, it's just enough of a cloud on the title that you don't want to have that. You want to have transfer restrictions. And I guess the doomsday scenario we're worried about is that a competitor comes along and takes out an interest and just starts creating problems for the company, information request, etc. The second restriction we'll always see is a lockup. And I have had super sophisticated parties come along and say, wait a minute, I know what that lockup means. That's just a big scheme to enrich the investment bankers. I won't agree to it, but that's pretty rare that when that happens. Almost always, most everybody will agree to a lockup. And what a lockup means is that the stockholder, in this case, the founder, common stockholder, agrees not to go out and sell any of their shares into the market within, say, 6 months of an IPO so they don't mess up the market. So just be prepared for that. Now, once in a while, you will see a set of documents that a cynic might say is over-lawyered, that not only has the restrictions I told you about, which are customary and usual, but also has a tag along, a drag along, a co-sale, all sorts of other restrictions that are more appropriate to a venture financing. And I suppose there are startups that are just so valuable from the start that you might want to have that. But for the most part, why bother? Because all of that stuff is going to get renegotiated and put in place when the investors come along. And it doesn't really mean anything until and unless that happens. So you don't often see those rights. But once in a while you will, because the specific facts of the situation demand it. Okay, moving right along here. The initial funding. So initial money is coming from the founders, friends and family are going to put some money in. Um, the founders are hoping that they can get some angels like Bob to invest. So they come and say, "What are our options here?" We've heard we can go on the internet and advertise. How about we put a Facebook post up that says, "Hey, we're in business. We're a startup. When you need money, call me." Or back before internet, it tells you how old I am. I remember once in a while somebody walk into my office with a letter they got in the mail saying, "Hey, invest in my company." Okay, what are the issues? Um, and I'm going to have to move more quickly now because we're already at 12:30. So legal issues. Number one, how do we document? What if the founders put money in? That happens, believe it or not. It's not all sweat equity, and it's not all you get to use my garage, and not all I'm going to assign my IP or stuff like that. What if they actually do put some cash in? Well, the mistake a lot of companies make is that, well, I'm a founder. I can be kind of informal about the documentation. I don't have to, have everything so buttoned down. The problem is that if one founder puts in cash and another doesn't, you need to have an agreement as to what you're getting for that cash. Because if you don't, you will have a dispute down the road. Because down the road, you're going to find out that the founder who put the cash in, he stands in a different position economically, and he might be better off if that were a loan that he gets repaid in preference to all of the equity, or he might be better off if that were preferred stock, that he gets, he gets whatever the preferred stock rights and preferences are, or he might be better off if it's just more common and he gets more of a bigger interest. And I've had it happen more than once where you've seen that dispute down the road, like, "Hey, I put this money in, and don't you remember that's supposed to be a loan?" Or, "No, don't you remember that's supposed to be more stock?" Or, "Don't you remember you just contributed that, because I worked harder. So I put in services, you put in cash. You got a service partner and a money partner." So we really need to document this to avoid those disputes. The type of securities offered to friends and family and angel money. Again, we do a whole hour on this, but to cut to the chase, it's almost always going to be a post money safe these days. It doesn't have to be. I mean, it's a lawyer's playground. We can make it common stock. We can make it preferred stock. We can make it a convertible note. We can make it a pre-money safe. But these days, it's almost always a post money safe. I'll talk more about that in a minute. Here's where people really make mistakes when they do not have legal counsel, is that every sale of securities for federal purposes has to be registered or exempt, right? Well, you're not going to file a registration statement for selling stock to founders or offering or even selling stock to your friends, family, or angels, right? You rely on an exemption. Similarly, here in California, every sale of securities really has got to be qualified or exempt. So we need to fit within both federal and state law securities exemptions. Now, having said that, two things. Number one, it's very easy to do that. I mean, the law currently has evolved to where when I started practicing, it was a lot less easy. It's a lot easier now. I'm going to talk about the exemptions in a minute. But just understand that again, usually we do it accredited only. That used to mean rich people. Now it means people who are less than rich, but they have enough money that they can afford to lose it based on objective criteria, based on net income and net worth. Or now, most recently, you can even infer that based on the amount of the investment. And then for state blue sky purposes here in California, that means that they are sophisticated, which includes accredited. So like I say, these are easy rules to apply and easy standards to meet typically. Where you don't meet them is when you want to sell stock to just every Tom, Dick, and Harry that you see. If you want to sell stock to the bartender down the street who just got out of college and is clearly not accredited, stuff like that. And I've seen stuff like that happen. So we do want to, or your relative who you just want to you want to allow them to get into this great deal. And They can go to Las Vegas and throw their money away. Why can't they throw it away on your startup kind of thing? I shouldn't say throw it away, gamble it on your startup. Um, I shouldn't say gamble either. I should say invest. Why can't they do that? Well, the securities laws restrict that. Now, we have had over the last several years some developments in this. Why do I say a private offering is so easy now? Because we have a safe harbor, like I said, that allows for an offering to accredited investors only, plus 35 unaccredited. And an accredited is a definition. It's net income or net worth, $200,000 of annual income or 300,000 jointly, current year, previous 2 years, or $1 million in net worth excluding your personal residence. That's the standard for accredited. What we've had come along in, I think it was 2012 in the Jobs Act, was the exception because under a private offering, it's private. You can't go out and advertise, you can't solicit. Well, the Jobs Act expanded that safe harbor to allow solicitation, provided two things: no non-accrediteds get into your deal, and secondly, that you verify. And the more recent change to this that made it easy is you can just assume that somebody is accredited by the size of their investment. Because I've had it happen where we get some very kind of famous tech celebrity that invests in a company and like, oh, we need you to sign this statement that says you're accredited. So now you don't have, there's an exception to the exception in there. And then finally, Reg CF crowdfunding. And this again came along in the Jobs Act, and every securities lawyer I know at that time was predicted that this would fail. It would be a big disaster. It would, widows and orphans would lose money, etc. Well, there were such strong restrictions on this that, first of all, it was less useful because it was expensive because of all the hoops you had to jump through. You had to use a platform. You had to have a statement filed with the SEC depending on the size. You had to get audited statements depending on the size of the deal, et cetera. And plus, you were limited to $1 million. Well, now crowdfunding has become a very slick, smooth process. We can do SPVs, we can do escrow accounts. We can go up to $5 million. So it has become a very viable way for companies to raise money. And importantly, the amount that a person can invest is so small that it has proven to be sufficient investor protections in the statute that I would say it's been a big success. And a lot of companies use this. And the other thing is like I said, every securities lawyer was opposed to this. Every VC I talked to said, we don't want to invest in a company that's got 1,000 crowdfunding people on their cap table. We won't do it. Well, as it turns out, they have done it. And it's even easier now because, like I say, we can consolidate all of those investors in one special purpose vehicle to avoid that, that 1,000 shareholder, AKA potential plaintiff problem, and also consolidate all that voting power. All right, let's keep moving. Advisors. Now, next thing the company is going to want to do, we've got our founding team, got my angels lined up. Bob is looking at my company, but I know Bob is going to say, hey, you need to, beef up your team a little bit. You need someone that's got some domain expertise. You need someone who can get you some customers. You get somebody who understands this aspect of the technology, et cetera. So we get some advisors. So we're going out looking for advisors. We found one guy who says, hey, I'll be your advisor. I'll raise money for you. Just pay me a percentage of what I raise. We find some people who have been in this business before and they know e-commerce really well. So again, we don't have a lot of cash. We're a startup, but we got a lot of stock. So what do we do with these advisors? Well, first of all, it's typically equity compensation. It's typically options. Sometimes we'll do restricted stock, but the grant of stock for services is taxable. So most advisors, they just want options, so they're not to pay tax. How much? And here we get away from law and into lore again, because a typical advisor will be about 1/4 or 1%. That's a typical. If they're really good, I've seen it go up to like 4 or 5% for celebrities that are going to bring a lot to the company. And I've seen it go down to, a tenth of a quarter of a percent because their contribution is commensurately less. Vesting, remember what I said about 4-year vesting for founders, for advisors, it's typically 2 years. And we hadn't talked about acceleration, but what I mean by that is an advisor, if you think about it, they're way different than a founder, a consultant, an employee, in that they have a very specific thing they're bringing to the company. And when that company gets acquired, the acquirer is going to have no use for the advisor. So if they're vesting over 2 years and the company gets acquired in a year, they're going to lose half of their shares, right? Or their option, their unvested equity. And more oftentimes, you'll find that advisors will be allowed to have acceleration, meaning they get full vesting on acquisition of the company for that reason. So way more often, we call that single trigger, meaning that there's just one trigger for the acceleration of vesting, meaning the full vesting, and that is the acquisition of the company. One of the hard lessons we all learned about this is that advisors, because it's a little fuzzy as to when they're actually terminating their service, so we put in place performance vesting and milestones, performance metrics and milestones, meaning that, look, if you as an advisor are bringing this particular value component to the company, you actually have to do that in order to vest, right? It's not going to be just purely time-based. It's going to be once you do bring me that customer, then you vest, or once you do whatever it is, you vest. Now, here's the big one. Remember what I said about the guy who's going to take a percentage of funds raised? That guy has to be a registered broker-dealer. And if they're not, you just cannot enter into that transaction because that would be an unregistered finder. And there was a time in this valley when we had finders all over the place. But the SEC has cracked down on this. The state has cracked down on this. California does have this little exemption that is pretty much meaningless. I've tried to use it. And even if it does work, you still got the federal law to comply with. So the general rule is they have to meet the requirements for registered broker-dealers in order to take success-based, transaction-based fees, meaning a percentage of funds raised. So be super careful about that. And by the way, if you're not careful about that, the transaction is subject to rescission, you're going to blow your securities law exemption, and in egregious cases, you'll attract the attention of the regulators who have been known to go after these things criminally. Okay, all right, we got our money, we got our advisors, we got our team. We're going to set up our website now. It's public facing, and it's a transactional website. People are going to be able to do transactions, and we've connected. We went and vibe coded the whole thing, and we've connected it and built it, and we're ready to go. We did a whole hour on licenses, so I won't spend a lot of time on that, but the moral of the story is, make sure you license in all the tools that you need to actually conduct this business. And that may mean invention assignments from the founders and other people who are working on this, including the employees and the contractors. But the two big things here is that we need a really good set of terms of service online. And it certainly is lawful and enforceable to just have people click through and agree to terms of service. In fact, it's amazing how much stuff I agree to these days online without ever reading it, because that's just the nature of the business. But the bigger issue that's evolving and changing is the effect of privacy laws. And California, as you might know, has a pretty robust privacy law that applies whenever you, through your website, are capturing personal information. And if you're getting an email address, that would qualify. And there is a threshold, a nexus threshold in California that seems like, oh, I have to be doing a lot of business there for this to apply. But actually, it's not that much. And I think the better rule is just to assume that you're going to trip over that threshold pretty quickly in terms of transactions or visits to your website. And that's just California. And if you're doing worldwide business, you get to be in a never land of having to comply with the privacy laws of California, other states in the US, and possibly the GDPR in Europe, and possibly the rules of other countries. So it's a bigger deal than you might think, and something just to pay attention to. Technology. I believe in patents. If you got something that's patentable, let's get a patent. But the trouble with patents is that that's going to be public. So the world's going to see it, once your patent issues. And kind of my rule of thumb on this, I'm not a patent lawyer, but I know where patent lawyers are, so I know when to call them. And on the patents, my rule of thumb, why don't we just go to it, on IP protection is that we want to rely on patent and trade secret. Let's patent the stuff that's easy to reverse engineer, because the world's gonna figure out how it is we're doing it and what we're doing anyway. So let's get federal registration protection so we can prevent that person from using it as long as I've got the patent. But let's use trade secret, meaning we're just going to keep it secret, this proprietary valuable information, for the stuff that's not easy to reverse engineer. Similarly, let's patent the stuff that's not going to change, and let's use trade secret for the thing that's constantly evolving, which is almost every software product. So that's intellectual property for a big component of the technology. And by the way, technology is different than IP, right? Intellectual property, we refer to the legal protections of the technology. Secondly, remember, we got a logo and a name that's really cool. And we get rights in it by using it in commerce, but we definitely want to, number one, make sure nobody else is using it. And that's easy to do these days. Anyone who can do a Google search can find out if they're likely to run into problems. But then we want to do what we call a patent and trademark office knockout search to make sure nobody else has tried to trademark it. And then thirdly, eventually, we're going to want to actually get a federal registration to protect ourselves going forward in case somebody else comes along and wants to challenge it. Importantly, anybody who touches the technology should be signing invention assignments. Okay, and what is that? That, say you hire a consultant to come out and do some coding for you or whatever it is, you want them to sign a document, an confidential information agreement and invention assignment, also called a proprietary information agreement and invention assignment, which basically says, look, everything I'm creating for you as part of this job belongs to you, the company. If you don't have that, you run the risk that they're going to claim that it's theirs, or they at least have a revocable license to it. And if that happens, then the company claim to have ownership of the product. All right, let's move along. All right, now we're up to the angels. Oh boy, and we only got 15 minutes left, so I'm going to move quickly. So Bob's the first angel money in because he is a prolific angel, and you're just so happy to have somebody famous like that on your cap table. And he gets a safe. And he says, well, because I'm such a big deal, not only do I get the normal safe, but I want a side letter. I want to be a board observer. I want pro rata rights. I want most favored nation rights, information rights. I want you to give me a representation that this safe is going to qualify for qualified small business stock. And the founders say, sounds good to us. We had no idea what any of that stuff means. All right, legal issues. So keep in mind, a safe is a simple agreement for future equity. Bob gives you his money now, but he doesn't get stock now. He gets a promise to get stock later when you do your first priced round, i.e. when you sell your first preferred stock. We used to do that through convertible notes, where Bob would lend you the money, and instead of repaying him the loan plus interest, you would give him stock. Now we just cut to the chase and say, look, we don't ever expect to get repaid. We sure as heck don't expect interest. We just want stock. So that's what the simple agreement says. Pre and post money, we've talked about that before. The big difference is that with a post money safe, Bob's percentage interest in this company is fixed. Doesn't matter how many other safes you sell, whether you sell 1 million or 1 billion. And that sounds really bad, but in practice, the numbers for most companies I'm seeing in startup land, it doesn't end up being that big a difference because we get to that price round so quickly. It's not like we have a tremendous amount of other dilution out there. So why agonize over over it. And from the company standpoint, super complicated to figure out what you've sold with a pre-money safe. From the investor's standpoint, they don't know what percentage they're getting. It's as if they have stock now that's going to be diluted down the road. And the market has really, I'd say 80% of deals now are post-money safes. And it wasn't that long ago, it was the other way around. It was 80% were pre-money safes. But, that's just one of those things that just is going to change in the market. The valuation cap is the idea that Bob says, look, your company is worth X now. You're going to use my money to get it to a Y valuation. When I do convert my safe into stock, I want it at today's low valuation, not tomorrow's high valuation. We say we will accommodate you on that because the safe is just a way for us to get this done quickly. So we say your safe is going to convert into stock at no greater than today's valuation, which we all agree is X. And you'll see X range from, I don't know, $4 to $10 million these days for a lot of new startups. I see it go a lot higher for companies that have more traction and get more traction quickly. The important thing for the startup founder to do is to learn to use Excel or use one of the commercially available online tools and figure out what you're giving away. You don't want to be surprised by that at closing. And this can be a tremendously complicated transaction if you've got pre and post money safes with different discounts and different valuation caps. Now, MFN is just what it sounds like. What Bob's saying is that, look, I'm going to do this really quickly without a lot of due diligence because you need the money today. But if you turn around in the future and sell another safe to somebody else, I have the right to elect the terms of that safe. So if you give somebody else better terms than you're giving me, I get those terms. That's most favored nation. We see that a lot by sophisticated investors. Information rights. Bob is saying, I want you to report to me. I want financials. I want to see your budget. I want to see your business plan, etc. We oftentimes see that. What you see less often in side letters for safes are a dividend replacement right, saying, look, I'm getting the safe instead of stock to accommodate you, but if you guys start paying dividends on the stock, you got to pay me a dividend as if I had stock. I don't know that I've ever seen a startup. Well, I have seen startups pay dividends, but it's extremely rare. You don't want to pay dividends, non-deductible dividends. You want to reinvest that money in a company and build out the asset. Board rights, usually for a safe holder, it'd be more like board observer rights, where Bob would say, look, maybe he wants a board seat, but maybe he just wants the right to sit in on the board meetings and hear what's going on. And finally, the tax treatment. The market has come around, and by the market, I mean the accountants that have to sign the tax returns, has come around to treating safes, regardless of pre or post money, as stock. And if they're stock, then they qualify for qualified small business stock. And what that means is that provided that holding period is met, the seller of that stock or the stock that the safe converts into can exclude up to $15 million under current law of the gain. 10 million is if the stock was issued before July 2025. So you'll see a lot of representations by sophisticated tax sensitive investors as to the tax treatment. They want to know that what you have is a qualified small business, so they get this QSBS treatment, and that you're not going to do anything to screw it up, which a company easily could. So be prepared for that. It's not a difficult rep to give, honestly, because the standard market rep these days is pretty watered down. It's really a good faith standard because we can't agree on what the IRS is going to do. We can't agree on what we'll do to make it more likely to get a certain result. Hiring, okay, now we've got Bob's money. So, we develop a tool, we pay some expenses, we pay the founders, and what do you know? We ran out of money. Well, now what? Well, how about we just start paying people in stock? Because we got plenty of stock. And we can't pay the landlord in stock though. But you know what? We've got all these employees, and there's this cash that we have to pay because we withheld taxes. We're supposed to pay to the government, but the landlord's at the door. How about we just pay the landlord? All right. And I don't have a lot of time left, but I do want, this is maybe the kind of the number one biggest thing that will tank a startup, because people just for whatever reason seem to think that these rules don't apply to startups, but I assure you they do. The employment laws, the labor laws, class action or misclassification is that's a problem that cannot be ignored, and that's something that you want to get involved in, because if you treat someone who should be an employee as a contractor, you've got the federal and state authorities on your case for withheld taxes you should have withheld, plus payroll taxes. You've got potential class action claims by the employees who should have gotten overtime pay and meal breaks and rest breaks and all that stuff. Um, and you've also got workers' comp and unemployment insurance that should have been paid. And there are criminal penalties that attach to messing up workers' compensation. So it's very serious stuff. And I've seen more than one company completely tanked. In fact, one company that I talk about in my presentation, they've raised $40 million in venture capital, and they went completely out of business because of a misclassification issue. So this is serious and one of those things you don't want to fool around with. The bigger issue, though, or not bigger, but another big issue from our fact scenario is that the company cannot use withheld taxes to pay any other expenses. Because the way the government looks at it, they call them trust fund taxes. In other words, that's not your money, right? That's the government's money you're holding. And you have to make those quarterly deposits or monthly, depending on the size, to the federal government of those taxes. And if you don't, you're stealing the government's money. And the government, the federal government, takes that extremely seriously. So seriously that they will not only hold the company responsible for that, they will hold all responsible persons. And that's almost anyone in sight. That could be a bookkeeper, who books the entries. And I've had many responsible person cases over the years, and those are very tough cases. You just don't want to be in that situation. All right. So, company needs money and it can't steal it from the government. So let's do a priced round. And Bob says, you know what? I'm your safe investor, but I'm also a VC as well as an angel. I'll tell you what, I'll do the priced round, but since I know what rough shape you're in, I want a really good valuation. So he gives them a term sheet. Uh, we've got a whole hour on term sheet terms, so I won't belabor it here, but here they are. Two things. Number one, all this is negotiable, and valuation is not your biggest issue typically. It is a big issue, but you've got all this other stuff. All this is negotiable. But secondly, the market has gotten extremely efficient. So we're going to expect to see things work a certain way. We're going to expect to see a certain type of anti-dilution. We're going to expect a certain set of protective provisions. We usually will see what we call 1x non-participating, not always, but usually, almost always these days. So just keep that in mind. And I won't go through these because we've done it before. Let me jump ahead a little bit because we've only got 5 minutes left. And to cut to the chase, company has taken the money. It was a little fast and loose on its representations because it needed the money. And then they got part of the financing terms where they had to have an audit, and the audit disclosed some discrepancies in the company. And now Bob VC, as opposed to Bob the Angel, is really annoyed. He's really annoyed. This company lied to them about these irregularities and might not have even been a lie. It's just sloppy practices. So now we have this contentious negotiation. Bob is mad and he says the CEO has to go. So we go play this game that is known in the Valley as Fire the CEO. And now we have a big negotiation with the CEO. So first of all, does their vesting accelerate when they get fired? And remember, sometimes we say if you get fired without cause, you get additional vesting. It's pretty rare, but you got to look because it might have happened. But there's always a carve out that says if you get fired for cause, you don't accelerate. So we're going to have a big fight over what cause means oftentimes. Maybe we get the CEO to surrender stock back to the company. And here's something kind of new in the West Coast anyway. is slipping into agreements more and more, what we call clawbacks. We see those on the East Coast far more often, and all bets are off if you're in a foreign country. You'll see all sorts of clawbacks. But here in the West Coast, it's been relatively uncommon until the last few years. But now I've seen them more and more. And a clawback means that, look, if you've been a bad boy and we have to fire you, not only do you have to give us back your unvested shares, you got to give back all or part of your vested shares. So this is why it's important when I said know who the client is and know who your lawyer is, because maybe the CEO agreed to a clawback way back when and didn't realize it. And now it's going to come back to bite them. I want to cut ahead a little bit. We did an insider round, and now we're coming to an exit. And it's kind of like we got a new CEO. He's done a great job. But you know what? My fund, Bob says, is coming to an end. It's only a 10-year fund, and we're in year 9. Time for us to sell this company. So they engage a banker. They get letters of intent. And of course, the company is not going to make enough to clear the preferences. Remember the preference? That's the fact that the idea that the preferred stock gets their money back first before the common gets anything. And management says, well, forget it, I'm out. If I don't get anything out of this deal, why should I help you sell it? So we do a carve out, right? We say, well, here's what we're going to do. We're going to take the first X% off the top, pay it to you, management, just vote in favor of this deal. All right. And that is the In Re Trados case, right? Because everybody's gotten together. They've enriched the management. They've enriched the preferred stockholders and all these other common stockholders. And by the way, all the preferred stockholders below whatever the preferences are, like the earlier series. I had a deal where we had a $500 million sale, and you had to get to like letter G before any of the preferred stockholders got anything. The founders got nothing. Optionees got nothing. The early angels got nothing. The early preferred stockholders, you can bet that was contentious.
God almighty.
That's Trados for you. You have to run, and that's process. You have to run a really good process to make sure that we don't end up giving everything to the litigators. Earnouts we talked about, M&A terms we talked about. And again, you can go back to our M&A session if you want to see the types of deals. But for now, I want to just close with one thing, and this is the part that it's important not to forget, is we started with a founder, we're going to end with a founder, right? Where does the founder come out of all this? Ideally, you'd like to make some money off the deal and not lose money, right? In other words, you don't want to lose any more than you've invested. So we're going to be careful about the indemnities. And if there is any upside, we want to make sure that we don't give it all to taxes. And that's what these issues are. With that, I'm happy to share these slides. Unfortunately, I just kind of went hog wild on this, and I did not quite finish. I have a lot more slides, and I have an hour to talk about. And if you want to read in depth about any more of these issues, you can read my first book, Dead on Arrival, or my second book, 10,000 Startups. Happy to share the slides. I'm Roger Royce with Haynes Boone. And thanks everybody for being here.